That is us. Kia ora tātou. Good morning, everyone. Welcome, councillors, Mr. Mohi, staff, of course, members of the public, and Mr. Henry from the press. And good morning and welcome. Could I ask Peter Bevan to take us through the prayer, please? Thank you.
Teach us to be generous in our outlook, courageous in the face of difficulty, and wise in our decisions. We ask this grace through Christ our Lord. Amen.
Amen. Okay, so we have no apologies. Councillor Barker is here. He had to take a call. Notices, I have a notice. And then I have a request for the reading of a personal statement, which I will get onto shortly. But my notice is quite simply the Governor-General's in Hawke's Bay on the 10th of June, which is the third day of our hearings. And he's requested that I spend the morning with him going around Hawke's Bay in an Army helicopter. So I've said yes. It's a request that the Council doesn't receive at all often, if ever, before. So I'm just advising my colleagues that the morning of the third day I will not be here. I'm not sure whether we will still be going then or not, but just giving a heads up that I won't be here. Okay, other notices? There's no other notices.
Oh, Councillor Dick.
Oh, Councillor Dick. Sorry, excuse me.
Leanne, you've distributed the original terms of reference, but the changes that are proposed, where are they?
On your...
Pardon?
On your... Yes.
Oh, I see. That's the red. Okay, thank you. Thank you.
That's good. Okay. One other notice here. Just remember to use your microphones today. I may keep reminding you because if we're not using the microphones, the recording doesn't pick it up. I've had a request from one of our colleagues to read a personal statement. Comes in under 3.8.12 of standing orders. It has to be with the agreement of the chair. In this case, that has been granted. Christine has a personal statement just to advise that following this we will be moving to the next item. It does not engender debate. Councillor Scott.
Thank you, Mr. Chairman. On Saturday, a protest group was sent to my home on the direction of another councillor. I wish to make it plain that I have no bone to pick with the protesters. I was reported in the paper as being an avid protester myself. That's something I cannot claim to be, well, not the avid part of it, but I uphold the right to freedom of speech and believe that opposition is healthy for democracy. Yes, I actually have been a protester. I marched with against the injustices of the war in Vietnam and the napalming of innocent civilians. I marched for a nuclear-free New Zealand. I joined marches in Hong Kong against the massacre in Tiananmen Square. And I marched from Tangoio to Wellington in the Hikoi of Hope, seeking a more equitable society. My participation has always been peaceful and based on truth. What I do object to is how the protest was directed at me and to my home by a fellow councillor by incorrect statements. I am therefore exercising my right to address this in a personal statement. The protesters were informed that I had a role in degrading the Tukituki and Nararora River. Mr. Chairman, I have degraded no rivers. In my role as a hearings commissioner, I've sat on hearings granting water takes. These have been properly assessed against the law, the Resource Management Act, and against all statutory plans. Throughout my time as a hearings commissioner, either as a member of the panel or as the chair, not one single decision made has been overturned by the Environment Court. Challenged, yes, The decision has always been upheld. That is a record to be proud of. And I know that that is a KPI that the staff work to. Secondly, the protesters were informed that certain identified councillors oppose water bottling, while other identified councillors favour it. The latter part is untrue, and it twists those councillors' recognition of just and proper application of environmental law. This council has a duty to process resource consents under the RMA, any national policy statement and environmental standard, and the statutory plans made under the RMA. Upholding the staff's integrity and processing those, as they rightly do, is our duty. It matters not whether you like the applicant or not, whether you like the primary producer or its product or not, whether you like the industry or not. The RMA is outcomes based. It is solely on environmental effects. It matters only that the adverse effects can be avoided, remedied or mitigated, and that the life-supporting capacity of the natural resource is sustained. This is based on scientific evidence. Whether there is a better alternative first come, first served allocation is a matter for either a change of the RMA or through one of its processes. It's a matter that was canvassed widely in 2006, and the Labour government of the day opted for status quo. Frankly, in trying to award value to establishing an order of precedence of who or what is more deserving of the water opens a can of worms. There is no easy answer, and that is why it must be addressed fairly and openly through informed and rational debate, and not through personal attacks. Thank you, Mr. Chairman.
Thank you, Councillor Scott. Right, let's move on. Conflict of interest declarations for today, there being none. Thank you. The minutes of the 29th of April 2015. Right, page 2 for accuracy. 3, 4. Page 5, page 6, page 7, page 8.
Chair, towards the bottom, there's a question and answer. The monthly report does not update progress on signed conditional contracts, and the answer says with the balance of 56 million cubic metres in negotiation pipeline. In fact, the total is 56 million cubic metres, so that it should actually read not the balance of 56 million, but a further 25 million. Just to make it clear what the...
It's the balance of the 56 million.
Yeah, but it sounds like 56 million
Plus.
further cubic metres is being negotiated. In fact, it's a further 25 that is.
Further 25 on the 15, is that what you mean?
A further 25 in addition to the 15 and the...
Yeah, okay, okay.
Yeah.
Yes, okay, thank you. You got that? Yes. Thank you. Page 9, 10, page 11, page 12. Someone happy to move?
Well, no, just, sorry.
Oh, sorry.
And again, on minor items, number 3, to be issued at 1 p.m. on Friday, and link will be forwarded to councillors as what?
As upstanding citizens.
As soon as
As
possible.
soon as it
or
beca-
something?
as soon as it became available, I think I indicated at the time I was going to be out of the office, so I forwarded as soon as I could. Yeah, so sorry, in the end, that's incomplete.
As soon as possible, is that?
Yeah. As soon
That was a
as.
very open-ended question, yeah, soon as. Very good English, thank you. Central Hawke's Bay translation, thank you, Mr Morphy. Someone happy to move that they are a true and correct record? Yep, Councillor Pipe, seconded Councillor Scott. All those in favour?
Aye.
Against? Carried. Matters arising from those minutes? Thank you. Okay. Follow-up items, page 3. Mr. Maxwell is here. Thank you.
Yes, through you, Mr. Chair. So I explored that liability risk from the earlier meeting, provided some further detail and discussions we've had with Waikato Regional Council around what they do and the insurance that they cover for that. And I'll also just note, perhaps it's not completely clear in the last 2 bullet points, in Schedule 1 of the conditions for the scheme, like I'd indicated earlier, the conditions anticipate some variation to the dam design, and if that is to occur, there's a process that follows that. There is a Category A recognised engineer who is the designer as part of the certification panel. There is a Category A recognised engineer who is in effect the project's engineer who is part of the certification panel, and then there is an independent Category A recognised engineer appointed by ourselves and the 2 territorial authorities who are part of the certification panel. So they go through the detailed design and they must certify it before it goes into the building consent process. So it goes through that level of scrutiny, then into the Waikato Regional Council building consent process, and then subsequently those 3 engineers become what is called the construction expert panel, and they oversee the construction of the dam.
Questions? Councillor Barker.
The engineering thing's all very well, but it's a red herring. What we're looking for here is the legal liability. And my question is, who actually issues the resource consent? The Waikato Regional Council or the Hawke's Bay Regional Council?
So it's a building consent, and the building consent is issued by Waikato Regional Council.
So the Hawke's Bay Regional Council does not issue the consent?
No.
All right. Because that's the issue, isn't it?
Well, in effect, we've delegated our responsibilities or role to Waikato Regional Council under a memorandum and a terms of agreement. Yeah.
Okay. But, so we've delegated, but still, is it our consent at the end of the day? The point I'm wanting to get here to is it's all very well to have someone have a insurance policy, but in the event of it, a legal team could drive past that and say that in actual fact, it's the Regional Council's resource consent. Even though you've delegated it to someone else, you maintain ultimate responsibility for it. And if we maintain ultimate responsibility for it, are we protected?
So again, my understanding of the process is that Waikato Regional Council hold the liability for it, hence they hold the liability insurance. So the liability sits with them as the issuing authority for the building consent. So there is no liability back to this council. They hold the liability, they hold the insurance, and that's why they have and specifically there is a clause there around insurances to say, are you protecting yourselves from liability?
But I would rather, who did you get this advice from?
This is from Waikato Regional Council.
But it's their advice, but I would have thought the first thing we've done is gone to our lawyers and got our own lawyers to check the legal position for us, rather than rely on them saying, don't worry about it, boys and girls, we've got it. I would have thought advice to our legal team would say, in the event that things go wrong, are we completely removed from any legal liability here? And if we have the prospect of legal liability, what do we need to mitigate it?
Sure, and so that hasn't been done, but certainly we can do that.
I wouldn't rely on their advice.
Sure.
Any other questions on that? Okay. Continue.
There was just 2 other matters over the page, and the status comments there are quite self-explanatory, Mr. Chairman.
On item number 3, as you know, we laid this paper aside at the RPC meeting. I would just ask that we not let this matter lie with simply the existence of of a explanatory paper from the staff that I would ask that we be a little more proactive going forward with this, that we ask the staff for something that indicates how the council might be in a more proactive role vis-a-vis this issue, which is not clear from the agenda item, is triggered essentially by the water bottling issue, and that those proactive steps could range from more significant public education on the issue through to how we are in fact processing or handling the issues that are coming forward via these consents. We had a report that basically focused on things that we could not do. It didn't really examine what we might do to get on the front foot on this issue. And if we don't do that, I think we're likely to see the kinds of concerns that were expressed on the weekend amplify.
Mr. Maxwell.
So just to clarify, what you're looking for is our kind of public awareness program around what we do and how we operate for resource consents.
I think that's probably the minimum, but but I think a closer look as to are there any grounds that we could rely on, excuse me, to be more proactive in or precautionary, let me use that term, in how these consents are being dealt with. There's, I think, reason to believe that more of them will be coming our way. And as you said in that last committee meeting, at some point, yes, there is a cumulative effect issue that would need to be looked at. So I don't know whether if you were to sit down and look at the whole proposition more closely, you would identify that there are other ways we might come at this, but I would say at the very least, there needs to be, I think we need to be more out front in putting this issue to people in a way that explains what we're up to.
So, yeah, I could regurgitate some parts of the paper because parts of the paper did address that, particularly around managing cumulative effects through policy change, which is in essence exactly what's happening at the moment through the tank process and the community engagement and dialogue around that, the development of more tools for understanding the resource and then sitting down with the community and saying, well, how do you want to manage the cumulative effects of water abstraction as one element of it. That's in essence what the tank process does. So we could perhaps more clearly explain the tank process and how that operates and what its purpose is and what it's going to do.
Just one last comment on it. I think part of the frustration out there is that people don't feel they've had an opportunity to engage us as a council. Having a paper received at the RPC, which of course nobody comes to, it's not really presented much as a public event, is not such an occasion. The tank process is an invitation-only stakeholders process. So yes, it's where some of these issues are being ventilated or could be, but none of that is really designed to engage the broader public on an issue that seems to have a rather deep vein of concern. So I think we need as a council to decide, you know, are we going to front up more proactively on this issue or not?
Councillor Bevan.
Chair, I was going to raise this under minor items because I think we also think we need a discussion about this in more depth than we've just had. I don't know whether you want to have a whole discussion then or whether you want to have an expanded discussion now.
Well, we want to stick to the rules around minor items. You'll tell us something and we'll nod and we'll move on.
Mr. Chair.
So perhaps you could ask a question now.
I was going to suggest that one of the really useful bits of discussion in that paper, around that paper, was from Tony Hopkins, where she suggested that it was an issue significant enough to require a bit of a workshop around the issues first come, first served, rights and interests over water, the national picture on water management, bring all of that into a council workshop with the RPC and start at the beginning, which is kind of the big picture, and then burrow into the detail as you see fit. So that is an option that you might want to consider exploring.
Yeah, but I guess my concern is that in the meantime, we've got no control at all over these applications that are coming before us, and although I agree, yes, the applications get processed by staff, we set the policies that determine how those applications are handled and what the criteria are and so forth under the RMA. And at the moment, I feel that we're really exposed. And the problem we've got here is the tank process is going to have a look at there's two sides to the equation, if you like. There's how much water is available to be, to be allocated, and how much is actually being used, and therefore how much surplus water is there. And at the moment, despite assurances I've seen from some of the people sitting around this table that there's lots of water left in the aquifer, we don't know the answer to the equation. We don't know either side of it. We know how much water's been allocated, but we don't know how much of it is actually being used, and we don't know how much water we can safely allocate out of the aquifer without putting it at risk. So there's a whole lot of unknowns in that equation, which really worry me greatly, and we don't have the answers to those things, and we won't have them reasonably accurately until we've completed the tank process, and that might be 2 years away. So we're sitting here really exposed in the meantime. That worries me.
I think, Councillor, through you, Mr Chairman, you have hit the nail on the head. There is no quick fix, and that's really the key issue around policy changes. There is no provision for a moratorium on water takes, and let's be clear, if there was provision for a moratorium, it would have to be on all water takes, not just certain end users, because the Act does not allow for, if you like, discrimination between those types of uses. So we have we believe a way forward in terms of explaining to the public what those processes are, and outlining how they can be involved, how they can get their concerns heard. There is a lot of work being undertaken and has been undertaken in the past and is being updated around the groundwater modelling, so we can be reasonably reassured about the effects of takes. But as I said, that those takes do not discriminate on whether they end up in a bottle or on a tree. They will be looking at the actual resource availability itself. So that's an important part of the overall setting of policy, not just around one particular use or otherwise. So, but I agree, it is potentially not going to move as fast as people would like, but that's the nature, I'm afraid, of policy development in a democratic society.
Okay, so one thing that we could do in the meantime is have all new applications for water consents publicly notified, so that the public have an opportunity to express some views on the matter.
The Regional Resource Management Plan specifies, among other things, not only the status of a consent, but whether or not it is to be publicly notified, limited notified, or non-notified. So we can't, again, because that has already been through a public engagement process and a legal process, we can't usurp that either. So if the application is not does not meet the requirements to be publicly notified, we can't, or you, sorry, can't just pass a resolution requiring it. I'm afraid that's ultra vires.
And as a Hearings Commissioner, Councillor, you are aware of that, I know. Councillor Scott.
My question was around just that, but referring back to the Act and to the direction of the streamlining bill on the effective notification. Perhaps Mr Maxwell could explain to us now what those notifications options are and the effect of not observing the Act and the judicial process that would open us up to.
So certainly the streamlining has certainly driven a presumption of non-notification, and the Act's pretty clear around the process you have to go through for notification and the checks you have to go through. And just reinforcing Liz's position that if you took a step outside of that framework, you would expose council to judicial review, because an applicant could rightfully say, well, actually you've circumvented due process, and challenge you on that. So there would be quite a significant risk in that, trying to unwind that through council resolution. But I completely understand your frustration.
Councillor Graham.
Thank you, Chair. We just can't continue to have esoteric conversations like this. I just want to, because this is hugely emotional in the public, and the public's currently looking at us that we are doing nothing, and sitting around having little chats like this. So I would want to pick up, first of all, we need to understand what we think about this, what we think we can do and how we can manage it and how we can talk to the public about it. So I would pick up on Mr. Maxwell's idea of a workshop as soon as possible, so that at least we are together, or at least we are in a debate. And I appreciate that you've taken this debate this morning when you didn't need to. It's not on the agenda. But this is such a serious, emotive issue in our community. We're having big impacts, and as I said previously, if we have a drought, to watch this space for emotion. This is in the middle of the winter, and we're getting this reaction. So we need to have that workshop as soon as possible and have a serious discussion.
If we were to put workshop on, leave it on as an action item, you'd be happy with that?
I
You'd
would
be happy with that as a first step?
Could I ask a question of clarification of Councillor Graham, please? The workshop, are you envisaging that being a council-based workshop or out in the community? Because we have been invited to Matahiwi Marae to, hold a hui there on this issue. So what were you envisaging?
I did actually envisage that we sat together in the first instance, but I'm not afraid to take this debate into the community. So if Matahiwi Marae is, if we're able to do that there, I think it's probably, I'm not concerned about that. Either way.
They've made the offer. So.
Well, then I would go for it.
Okay.
Why can it only be one track? Why is one mutually exclusive of the other? Why can't we do both? I would have thought it would be really important for this council and councillors to sit down and have a clear, good debate among themselves to figure out what it is that we think is important here, what is less important, what the issues are, and get a clear view on that. And from that, we then have a debate with the public, and the public inform that. We could do both at the same time. They could be run in parallel. I don't see it being one or the other.
So if I take us back to, action items here, let's make sure that these sentiments are contained in what happens next, and don't drop off the radar, remain as an action item. Thank you. Other questions? So I'm happy to move that we accept this item. Follow-up items. Thank you, Councillor Bevan. We have a seconder for that. Thank you, Councillor